October 19, 2017, Muslims for Human Rights, Executive Director Hassan Abdile and I, the Chairman of the Board, challenged in High Court through our lawyer, Evans Owonjo, the appointment of 290 constituency returning officers and their deputies. The repeat presidential poll was 7 days away. We averred that the process that led to the appointment failed to follow the laid-down procedure of the law. The appointing authority, Independent Electoral and Boundaries Commission, IEBC, ignored the need for transparency and accountability in the process. IEBC had violated the provisions of Regulation 3 of the Election Regulations 2012. The electoral agency had not provided lists of returning officers to political parties at least 14 days before the appointments were made as required by law. And on October 25, 2017, at around 11 a.m., Judge George Odungas ruled on our favor, finding the appointment is illegal. However, the same day the Court of Appeal President Paul Kihara, now the Attorney General, impaneled 3 appellate judges who, in record time, suspended Odungas' ruling. Without holding any sitting, Justices Erastus Githinji, Martha Koome, and Fatuma Sichale quashed Odungas' ruling. They arbitrarily issued the orders. On April 19th last year, through our advocate, Evans Owonjo, we complained to the Justice Service Commission over the conduct of these judges. The day these judges issued the orders had been gazetted as a public holiday. There was no functioning registry and staff on that particular day. Furthermore, at the time of quashing Odungas' ruling, all the 3 judges were based outside Nairobi. Githinji was in Kisumu, Koome was in Malindi, and Sichale was in Nyeri. The 3 could not, therefore, be at the same place, giving short notice. Rule 2B of the Court of Appeal says an application is first made under a certificate of urgency before one of appeal judges certified as it is urgent. Who certified the appeal on Odungas' ruling as urgent? Which parties were present when the Court of Appeal quashed the orders? No parties were present, despite the matter being inter-parties involving adverse parties. To prove that the judges did not have a sitting, our letter to JSC requested for CCTV footages of the court premises between 2 p.m. and 6 p.m. on October 25, 2017. We also requested the Commission to provide us with the October 2017 driver's logbook and trip for judges. Surprisingly, JSC put up a full-on defense of the judges and dismissed our complaint. In a delayed and carefully awarded response, JSC only tackled the CCTV part, saying the Supreme Court, where judges allegedly sat, is not equipped with the cameras. JSC failed to address these pertinent issues that bring to the spotlight the conduct of these 3 judges. Number 1, the judges did not sit and contested that day. 2, there were no court proceedings of the alleged sitting of the 3 judges. 3, how did Attorney General Paul Kihara, then the President of the Court of Appeal, know about the urgency of the court appeal by the IEBC? 4, where are the proceedings of the President of Appeal sitting and certifying the application as urgent? 5, the 3 judges allegedly had an appeal and was never certified as urgent. 6, the 3 judges allegedly had the appeal in the absence of other parties as required in such hearing. 7, if indeed the judges had the appeal, they did not do it in open court, thus acting in unethical and violating judges' obligation of impartial conduct. 8, Court of Appeal cases which were allowed by Chief Justice to continue October 25, 2017, did not proceed on that day. Through our lawyer, Evans Orwenjo, we had written another letter to JSC to have the complaint re-evaluated and pertinent issues raised addressed. The independence of the judiciary is being questioned by the fact that the conduct of Justice Githinji Sichale are not being investigated. The judge's action led to the election of President Uhuru Kenyatta and his deputy William Ruto, which we consider invalid and illegal. Justice Githinji Sichale are therefore not fit to hold public offices. JSC should dismiss them with immediate effect. We shall move to court should the JSC fail to act.